John Crook has been found guilty by the judge in the Ohio courts. Yet again, he's been debunked. On January 10th, 2024, went to court with John Crook and LIEnette Preston. You know, the two exes. He's her seventh ex. You would think at number 6, she could have gotten it right. You would have think he would have been bright enough not to make himself number 7. But yet, they're there in court. Both of them found guilty, which we'll find out exactly what the consequences were. But you have to understand first that they're not only in Ohio court for contempt of court, violation of civil protection orders, they're not only going to be in Ohio court yet again for breaking the civil protection orders in person. I'm requiring them, requesting of the judge to enforce them to be in Ohio in person. No more of this Zoom garbage. But they're also in federal court right now. And it's pretty interesting that John Crook in federal court wrote this. Oh, wait, except he didn't write it. First of all, he can't put together complete sentences. And second of all, we know there are other foolish people attempting to help them, but every attempt further incriminates them. So this is what Crook actually submits to the federal judge in the federal case, which is for extortion, defamation, and the list kind of goes on and on. It says, I'm a disabled man helping Miss Preston raise her disabled child. Now we can stop right there because during the Ohio courts, Crook made an emphasis that this child is his. And now he's admitting she's not. Nope, nothing to do with it, except he's saying, I'm helping Miss Preston raise her. Okay, all right. By the way, this is the same man that Miss Preston states all the time is, abusing her, all right? In all kinds of different ways. But somehow he's a help now? How about Miss Preston can't find anybody else deranged or mentally unhinged enough to be anywhere near her or around her, and he's the only one dumb enough, and so he's the only one that's there. That's what it really amounts to. That would be my opinion of the truth. Yet again, debunking the crook. All right. So then he goes on to say to the judge in the federal case, I'm on a very limited income. Now, let's just look at that for a second. Most families are lucky to have one income. This, if you can call it a family, or these two freaks in OR Crooks have not just one income, not just 2 incomes, to my knowledge, 3 incomes. Yeah, he's getting money from the government, she's getting money from the government, and the child, from my understanding,
well, according to the paperwork,
it says
getting
money from the government. This is a family of 3 incomes. Not 2, not 1. 3 incomes. Now, my family, there's only 1 income. And it isn't mine because I make nothing. A big, fat 0. Come to think of it, there's no income. It's a problem. But, someday I'll figure out the solution to that. I mean, maybe I could take some tips from LIEnette and Crook. They seem to know how to make this work for them. Ms. Preston took out a protection order in Levy County, Florida on Mr. Hales, and finally, with the help of friends. This is the same woman who's posted she can't keep any friends. God didn't make her to have friends. And everything I'm sharing with you right now, I have all the screenshots to back up. By the way, these individuals, with their help, aren't friends. They've never met anybody in person. Now, I get it. You can know people online. I know a lot of our viewers and their personality, and I don't know them personally. But I'm not personally going to call them a friend because I have never, ever met them to be able to call them a friend. Not that I would not want them as a friend. Not that I don't know what they're... there are a lot of people behind a computer can have a very different personality than they do person to person. Very drastically different. For example, George has a very different personality behind a keyboard than she does on camera. or when the camera's off. There's 3 different people I get to see. But I know George personally, and George knows me. Huge difference there. And so he goes on to say, was able to come up with a retainer fee to hire an attorney in that case. Oh, thanks to Patty. And then we go on, that resulted in Mr. Hales going to Ohio. Obviously, that did not result in Mr. Hales going to Ohio because they got a retainer in court. Mr. Hales already had a civil protection order against them from Ohio by the time that LIEnette actually got a retainer for the Florida courts. But I digress. Okay, that resulted in Mr. Hales going to Ohio, his home state. It's so funny that they submitted paperwork begging, this is the paperwork, begging for an attorney. But they submitted paperwork wanting to have the entire thing dismissed in federal court, stating that I don't live in Ohio, that it's not my home state. And both of these fools put in writing to the courts that Ohio is my home state.
Does that mean they both debunked each other?
Debunked! Boy, they must like debunking too, because it feels so good. All right, getting a retaliating protection order on both of us. Well, that's funny because I sent a cease and desist. I attempted to get protection order in Florida. I've gotten a protection order in Ohio. I've attempted to get more protection orders in Florida. And none of this is retaliatory. Once I announced in a live stream I was getting a civil protection order in Ohio, LIEnette then went to the courts to try and get an injunction. The timeline is all there. The evidence is all there. It's all there. So all of this is garbage. Okay, but we'll keep going on. And he says, I couldn't fight that case with any hope of showing the truth being unrepresented. These are the fools that literally used my own videos proving their guilt. And yet they want to say, I couldn't fight that case with any hope of showing the truth being unrepresented.
Your Honor, it happened in Florida, not Ohio.
Your Honor, it all happened in Florida. What's that have to do with Ohio? How about these two are so freaking stupid and foolish that even with an attorney, the attorney would just say, don't open your mouth.
Wouldn't be able to help
Ever. Okay. No attorney is going to be able to help the aspect that they're beyond guilty. And he goes on to say, I had an order placed on me, even though I'm completely innocent of his charges. Innocent. And yet, you have a court declaring guilty, not only for the civil protection order, but the breaking and the violating. And I'm going to let you know what the consequences are here. I'm pleading to the courts. I'm destitute to the point I can't finish building our house. In the highlighted there.
Yep.
Destitute to the point can't finish building the house. Hold a second. Now, because I have them in court, they can't build the house. Okay. I've already shown some screenshots, some text messages of other conversations from 2023, 2022, 2021 in regards that they couldn't build the house. So how about let's take a look at what this house truly is. We're going to flash back to when the Fish and Wildlife officer actually showed up on the property and LIEnette and Crook aren't there. What I want you to pay attention to is the trash, the utter trash, which, by the way, they keep posting it's not dirty and trash like I say it is. Well, the camera and the evidence and the proof says different. And wait until he goes into the it's a shell thing. What they claim is their barnuminium. And all you're gonna see is trash.
Hi, kitty kitty. Brrr.
Doesn't look like they ever had an intent to even build a house. Just something to throw more trash in. And he goes on to say, I can't finish building our house. At this point, by the way, this mirrors exactly LIEnette's letter. It's just ridiculousness.
paste.
They copy and pasted, and I'm sure it wasn't even them because there's punctuation. There's still misspellings, but there's punctuation errors. It's ridiculous.
Well, if I were to guess, she wrote it and paid attention to punctuation.
Oh, for once? Okay,
Yes.
well, we'll see. All right, at this point, or care for our daily needs, as every penny will go to Miss Preston's attorney now. Mr. Hales has said he'll continue with motions and legal things until we're financially destroyed. Again, you cannot financially destroy somebody who claims from the very onset that they have no finances. I don't understand this whole logic. We're going to be financially destroyed, yet we claim we have no money and we beg from everybody with hundreds, literally hundreds of GoFundMes. All right, let's keep going on. And then when Fish and Game are called out because they say they have no food to feed and they can't even feed themselves, then they have to go online and say, we have plenty to take care of all of our needs. One or the other is the truth. Which is it? We already know it's scamming and conning. You know that as well. Okay, so it goes on to say that we are involved in 3 cases now. Well, they're actually involved in more cases. So you've got county court in Florida, which now Judge DeThomasis is being removed from. You've got federal court in Florida, which they are being sued for extortion, defamation, a list of other things. You have Ohio court, which they are now going to be in another case where they're going to be required to show in person. That's 4. You've got another family court in Florida contesting this adoption of a child. From my count, that's 5. And there's actually another one coming as well. There will be 6. Not 5, but 6. Okay, but let's keep going on. Because he says they're in 3 cases. No, they're in many more. Oh, by the way, anybody can sue anybody for anything. Now, that doesn't mean that a lawyer's going to take on the case. That doesn't mean a court's not going to throw out the case. If there's no basis for it, it's never going to fly. But there's a tremendous basis for viewers actually filing suit against Crook and LIEnette for the things that they have said and done to the viewers. But number 6 is coming. All right, we're involved in 3 cases now. The TPO in Levy County, which is temporary protection order. His PO in Ohio, which is permanent order, where he continues to charge us with contempt. Well, they've been found guilty, and they're going to show for another contempt of court. Well, I actually don't think they're going to show, but they're going to be legally required to show. A video was put out this week by Mr. Hale saying he's bringing yet another suit against us. Please, I'm begging. Crook kind of sounds like the chicken over there. I'm begging. I'm begging the court for an appointed attorney because we stand to lose everything we have in this world, including our beautiful child. So
That's definitely a LIEnette line.
So this is a LIEnette line, copy and pasted to the federal court. And understanding that beginning of this, LIEnette wrote this and literally stated that this was not his child. And now there's a possessive pronoun here stating our child. So it's not his child in the beginning. Now it is his child. None of this makes sense. I mean, can you imagine being a judge? The judge on the federal level is not a DeThomasis. DeThomasis is the bottom of the barrel in regards to judges. That is as low as a judge as you could be, okay? And then the qualifications to get to the higher and the higher and the higher, he'll never make it. He absolutely could never make it. And so
He'll do great as a professor in a classroom.
that's probably where he should be. And we'll keep going on, though. But I'm begging the court for an appointed attorney because we stand to lose everything we have in this world, including our beautiful child and our freedom and the home we're building for her, who is 4. We can't fight these fraudulent. You see that there? Fraudulent. Mm-hmm. How is it fraudulent when it's actually based on truth and evidence?
Factual findings.
Yeah, interesting. With an attorney who knows far more than we do. My income is SSD. She changed this line for him because she gets SSD and SSDI. He's getting SSD and it doesn't go far. Don't forget, they met on a website for STDs, so they have that going for them too. And I've just had my fifth knee replacement. 5 knee, no joke. It says my fifth knee replacement. Fifth knee replacement. Now, last I counted, 1, 2.
Well, he was septic. So
maybe
he'd have to go back
3,
in.
4. 5 knees. He's got 5 knees. He's doing all right. And now both have been done in 2 years. Thank you. Sincerely, John Crook. Let's see exactly what the judge had to say, because this will be the same judge that will be presiding over the next contempt of court hearing. Remember when they went to town hall and they stayed there for an hour and a half when George was there. They didn't even remove themselves after the sheriff deputies came. And the sheriff deputies were frankly useless, did absolutely nothing whatsoever. These two should have been jailed immediately. But that'll be the next case. Now, in Ohio, the charges can be up to a $1,000 fine and a year in jail. Florida is pretty much the same, except Florida will jail you immediately. Except Florida is playing games with the Ohio orders. Well, I guess we're going to have to leave it to Ohio to take care of this Florida stuff. All right, here's what it has to say. It says, Plaintiff Jeremy Hales versus John Crook, the defendant. This matter came before the court on a motion to show cause. Remember, show cause means to give evidence. So John Crook has to give evidence why respondent John Crook should not be held in contempt of court for violation of the full civil protection order issued on October 31st, 2023. And as a matter of fact, George literally just got off the phone with our Ohio lawyer about the next contempt charges, right?
I did.
Okay.
And John Crook's show of cause was, Your Honor, this happened in Florida, not Ohio. That was his show of cause.
There you go. All the evidence. These two. Okay. So let's keep going on here. So it says a hearing was called on the record on January 10th, 2024. That's when we were in court for the contempt of court hearing. And Jeremy's attorney appeared in person with his client, Jeremy Hales. Respondent Crook appeared via video conference. Now understand that these two have neglected, they have abused the entire system of Zoom and have upset the court to a point of we are mandating that they must be in Ohio in person. And I know you already know if they don't show, then an arrest warrant can go out. And so, and if somebody like Patty or Paul are dumb enough to actually give them the money to travel to Ohio, well, I'm pretty sure my local police force will be ready for them.
She'd have to get 2 rooms because they stay in separate things.
That's true. They do stay in separate things. Somebody's going to have to pay for 2 rooms. Well,
she'll probably make them sleep in the Jeep.
I'm sure there's
sleep in the Jeep.
2 sheds out there somewhere for them. Okay. So we'll keep going on here. The magistrate ordered the hearing would proceed, and petitioner Jeremy Hales presented testimony and the evidence in support of his motion for contempt. Hales testified to the following events in support of his motion for contempt. Number 1, Hales identified Exhibit A, a screenshot that Hales took of the post by Crook from a shot on October 25th, 2023, after issuance of the civil protection stalking order. The screenshot included photographs of, we'll say X, but put an S at the beginning of it, toys. Hales testified that he believed that the posting of the item was by Crook and was directed at Hales and was a violation of the protection order. Number 2, Hales identified Exhibit B as a social media post. But, the funny thing is Crook is blaming this on their followers, because LIEnette is a minister now, the pole dancing, stripping minister, okay? And so, obviously, she's got a cult following, and it's small. It's very small. They all have very small pipes. They all have very small driveways. They all have very small minds. And so, that's typically who follows in a cult, somebody very small-minded. And so he's blaming it on his cult followers who have dranken the turtle soup. And the funny part of it is, to me, is their cult followers are only incriminating them further and further and further and further. Number 2, Hales identified Exhibit B as a social media post posted by Hales in the social media group Citizens of Levy County. Hales testified that Crook commented on the social media post as follows: "No, but they'll film your children and use them in their next videos to make money on them." That's in reference to Christmas in the Creek. Number 3, Hales identified Exhibit C as a screenshot of people who reacted to the social media post by Hales, and Hales testified that John Crook is listed under the people who reacted with an angry face emoji. Hales testified that he believed that this contact was a direct violation of the protection order. He reacted to my communication via third party on Facebook. Number 4, Hales identified Exhibit D as Crook's Facebook profile. Hales testified that he clicked on the profile after the profile was listed in Exhibit C. Hales identified a minor on the Facebook profile as daughter of, look right here, daughter of Crook. Now, if you recall, my lawyer actually says, Mr. Hales, can you identify this child? And I state, yes. And he goes, is that the granddaughter of Mr. Cook? And Crook goes, that's my daughter. Well, that's funny because we just looked at federal documents that clearly state that there is no daughter of Crook.
It's her child.
Interesting. It's only LIEnette's child. So apparently, and I stated, well, alleged. That's up for debate and question. And Crook, in his federal court documents, actually proved and debunked himself yet again. Oh, debunking. It makes me feel so good. And I guess Crook likes it too. It's so good.
When they debunk themselves.
So good. So good. Okay. Number 5. Hales testified that on October 30th, 2023, Hales saw Crook pull into the Otter Creek Sheriff Department parking lot in a white Jeep Gladiator. He testified that the white Jeep pulled right next to his vehicle. Hales testified that he was scared and anxious by the scene of Crook at the Sheriff Department parking lot. This was day 1 when we got back to Otter Creek. As we announced the previous evening during a live stream, the first place we were going was the Levy County Sheriff Department. And here is that picture. It's interesting to me, and I may even say odd, but I don't use that term often enough, that Deputy Scott Tummins was the actual deputy who came out to help me. And when I came with the hit email that he had sent to me, to this day, we still don't know how they knew where we were. And he mocked, he made fun. He said, all of this is just for content. Interesting. What did he do? He should have arrested them immediately. As a matter of fact, the interesting part of this has all been filed for violation of the Civil Protection Order in Florida. And what has Florida done about it? Literally nothing. As the same with LIEnette's. What did Florida do with the issues that LIEnette was held in contempt for by Ohio? Nothing. They actually said it's not contempt. That's odd because the state of Ohio says it is. And they've been found guilty. They've both been found guilty. Particularly, they both have been found guilty for the sheriff's station. And guess what Florida did? Nothing.
We got an empty promise on that because it sounded like they were going to.
Nothing. They did nothing. So now, I just had a conversation with Mark Feather. I have a conversation with him as well as I landed in Florida. Are we going to pull the contempt of court, the violations from Ohio into Florida and force Florida to enforce the actual contempt of court, the guilty charges that Florida has tried to sweep under the rug now? This is going to be interesting down here in Florida, which means I'll probably be flying back and forth, which, just out of curiosity, why are you in Florida?
There's a multitude of reasons why I'm in Florida, but we'll save that for another video.
Oh, okay. Well, the first one being the temperature, the second one being the work. All right. So we keep going on here. Number 6, Hales testified that on November 13th, 2023, Hales had an interaction with Crook on the road outside the Hales property. Hales testified that when he pulled his vehicle out of the road, that he saw Crook walking in the road. Hales testified that he slowed his vehicle and he said to Crook, 10 feet. And Crook responded back with Hales, suck my quack. Okay? His tic-tac. He said, suck my tic-tac. And Hales testified that Crook's failure to clear the road and his statement to Hales was a direct communication and a violation of the protection order. Number 7, which the funniest thing is LIEnette. Okay, so let's go back to number 6. LIEnette begs the judge in Ohio, I want to show my version of what happened in the road. And the judge allows her to submit it and send it in. And on her recording, her video recording, the judge hears Crook tell me to suck his Tic Tac. It's on her recording. The irony of all of this, because you can't hear it on my recording. Only I can. The human ear picks up way more than the speaker or the microphone on the phone. But on her phone, it's loud and clear for the judge. The judge puts in earphones, hears it clear as day, and he's found in contempt for it.
Her telling him to shut up confirms that he was talking to you too.
LIEnette literally brought the charges on Crook.
She threw herself under the bus.
If I was Crook, I would be so upset at LIEnette. Like, ridiculous this is. How dumb can these two be? All right, number 7. Because of LIEnette, Crook is found guilty. But number 7, Hales identified a video from December 31st, 2023 as additional communication from Crook when George was driving from her home to a separate property when Crook yelled at George. Here's what happened.
This is Lee County Sheriff's Office.
Hi, sorry I missed your call.
That's quite okay, ma'am. My dispatch was unable to find an active injunction in the state of Florida at this time, so that's why I'm writing the information report. So, I talked to Mr. Cook. Mr. Cook stated that he, made the statement of stop filming me.
Okay.
Is what he said. He said, and I thought, put it in my report. I can't prove, otherwise I cannot prove anything else.
Yet again, Crook incriminates himself. It's so easy. It is literally so easy. Don't communicate. Guess what I do? I never communicate with them. I don't want them to text me, to call me, to talk to me. When I drive by, I don't want them to even look at me. But they have every legal right to look at me. I don't communicate with them. You know what LIEnette should have done as soon as she got a civil protection order? She should have deleted my name from her phone. Guess what Crook should have done? Deleted it. All of it. No, what did they do? They put all my information out on the internet. Let's just debunk something else as well. Because LIEnette loves to say that she has always gone by the name, what was that? Oh yeah, that's right. Michelle, her daughter's name. All right, well, here's a message in August 8th, 2022. Notice the bottom. What does she sign?
She signs it Lacey.
Lacey. 2022. Oh, what's the name of her Facebook? What's her name there?
Senior.
Oh, Senior. Okay, Senior. Because we called her out on using her daughter's name for scamming and conning. So then she changed her name to Senior. But she says she's used Michelle her entire life. Yet every document has LIEnette. And here on August 8th, 2022, we're not even in court yet. No court has even been talked about. She goes, I just heard the news. And she signs it Lacey. Wow. Why would an individual who has always gone by the name Michelle sign Lacey to Steve?
Her stage name?
Yeah, that was her stage name. It's self-given. It's not even a legal name.
Yeah.
It's self-given, as is Alexis. It's self-given. It is not legal by any stretch of the imagination. It is literally all self-given. She has named herself all these things. None of it is legal at all.
We do have a screenshot of that.
Okay, number 8. Hales identified Exhibit 2 as a video taken by George. The video shows George's interaction with Levy County Sheriff related to Crook having a verbal contact with George. And in the video, a sheriff can be heard talking to George. And George could not recall what Crook said to her, but stated that Crook puffed out his chest and was yelling at her as she drove by. And the sheriff called George back after speaking to Crook. And Crook admitted to the sheriff, he said to George, stop filming me. Now, first of all, I think that's a clear and blatant lie, okay? I do not believe that's what he said to her. Nor does George believe that, nor does the judge believe it, nor does anybody believe that's what he said. He's lying to cover up what he truly said, which was something vile. And then as he's lying to cover up the vile thing he said, he literally incriminates himself with the deputy. He's trying to cover up what he really did. He literally tells the judge, the deputy, everybody in the world, oh yeah, I communicated with her. Breaking the civil protection order. I know, I'm at risk by saying this, but how dumb can
Well,
you
that's what
be?
makes them so dangerous.
Their ignorance, their stupidity, their foolishness, their arrogance of they can do whatever they want in Florida makes them so dangerous. Now, a person may not be physically, their physical stature may not be intimidating, but what they can hold in their hand, and these two love to flash it around and all over social media, talking about what they're going to pop in our backsides, that's very, very dangerous. Number 10, Hales asked the court to grant attorney fees to find Crook in contempt for violating the civil protection order. Number 11, on cross-examination, Crook questioned Hales. This is where it really got good, where Crook was cross-examining me. Number 11, on cross-examination, we are getting to the consequences. We're very close. On cross-examination, Crook questioned Hales about the incident at the Sheriff's Department parking lot. Hales testified that Preston/Crook vehicle was initially at the front of the Sheriff's parking lot, while Hales' vehicle with their trailer was in the back of the lot. That Crook and Preston vehicle was then moved to the back of the parking lot next to Hales' vehicle and remained there until a deputy forced Crook and Preston vehicle to move, which was Tummins. He's the one that told them to move, when he should have just immediately arrested them. Another failure on the part of Levy County Sheriff Department. Number 12, Hales admitted that he did not hear the deputy tell Crook where to move the vehicle. Number 13, upon questioning, Hales acknowledged that Crook was on a walker in the road, but denied knowing what Crook was doing in the road. And yet the next day, he's not on a walker, nor is his leg wrapped, nor is anything. This was all a setup, just like being at town hall. Number 13, and all of these setups just blow up in their face. Number 13, upon questioning, Hales acknowledged that Crook was on a walker in the road, but denied, we're on number 14. Hales testified that he drove past Crook's property on his way to his other property. And number 15, upon questioning, Hales acknowledged that he has multiple entrances to his property. Toontown, baby! Population 1 is just one area into my property. And he has not had measurements from the distance to his property to Crook's property. Now, we have from Google Maps know that every single entrance is less than 500 feet away from their property boundaries and borders. And so even with the temporary injunction that Judge Craig DeThomas has put on me, there's no way I can stay with under 500 feet. And so, but this same judge likes to put me in danger going out on one of the most accident-prone intersections in all of Levy County. Now, you may be going, but Crook and LIEnette are dangerous. Yeah, absolutely they are. But when I have this going, they become less dangerous because this, frankly, is more powerful than what they pull with a finger in their hand, because then they know they're done. And so I can protect myself driving by with this. I can't protect myself in an intersection driving by with this. All right, let's keep going on, though. Number 16. To the video of Crook yelling at George, Crook challenged whether the video contained audio of him actually yelling at George. And Hale stated that the video shown in Exhibit 2 is the video of Crook yelling at George. Number 17. Remember, the judge is just doing a summary of everything that happened and where she pulls her evidence from for the final judgment and consequences. 17. Hales acknowledged that there is no recording of Crook yelling at Hales outside of the courthouse that I submitted. And then LIEnette submits it, and she pulls the audio, the judge, and hears it for herself. No. That was when he told me to suck his quack. This is, Hales acknowledged there's no recording of Crook yelling at Hales outside the courthouse. That was the different one. There's so many incidents. It's very, very difficult.
She used your video for the post office.
Yes. She also used the video for the post office. She submitted video of the incident in the road.
Afterwards. She's lucky the judge even allowed her to do that.
Number 18. Well, I'm sure the judge knew she was just going to further incriminate herself, and the judge wants this to all
just to
end.
confirm,
So the judge is going, yeah, go ahead.
And you guys didn't object?
No, we're not going to object her sending video that incriminates them even further. Number 18. Hales admitted that he saw Crook and Preston outside of the Florida courthouse for hearing number 1. He drove by, then he turned around to go past them again to film them. Number 19. On direct examination, Crook denied yelling at George and denied yelling in front of the courthouse. Crook testified that the reason Hales filed the motion for contempt is an ethics violation related to the mayor of Otter Creek. How stupid. So, hold a second. So, in the federal paperwork, he says all of this is about retaliation because she got a temporary injunction on me. Now, in Ohio paperwork, he says that it's because of an ethics violation that mentions me, that he filed. Which, by the way, he filed that on Madam Mayor Therese, and all charges were dismissed. In other words, no evidence, no truth, no anything to it whatsoever. So they can't even keep the story straight. I've heard everything from we want their child, we want their land, we want. What we want is for them to leave us alone and shut the freak up. You know, the creek, the freaky creek, the Otter Creek. Okay, so on cross-examination, Crook acknowledged that he has a Facebook and that he commented on the Christmas program sponsored by the Hales. And Crook denied that he posted that Facebook photo, Exhibit A, which has photos of adult toys. Related to the which he did post it, but related to the incident in the road, Crook testified that he told Preston to suck my quack and that it was not directed at Hales. And Crook admitted that on December 30th, 2023, he yelled to George, "Stop filming me," when George was driving down the road. The plaintiff moved to admit all the exhibits. All exhibits were admitted. Counsel for petitioner requested leave to submit a supplemental affidavit for attorney fees. And then, to date, no such affidavit has been filed. So I have touched base with my attorney on this. My attorney did not submit supplemental affidavit for attorney fees, which in this particular incident was $3,000. He is, now that we have the paperwork, he is resubmitting that, and he's submitting for the next contempt of court hearing as well. So the total should be, in my favor, $6,000 that LIEnette and Crook will have to pay. Okay, so then she goes on with all of the legalese, okay? This is what gives her the right to make the decisions and all the legalese that and it's quite long. And she even goes down here and she mentions, listen, this is what's going on. 500 feet. If you're on your respected properties, it's 10 feet away, which is why I said 10 feet. Actually, he was breaking the civil protection order being in the road. If he would have just stepped over onto his property, he would have been fine. He would have been completely and totally fine. But did he? No, he did not. All right, so it goes on, and this is where the consequences come in. Upon review and consideration, the court finds respondent Crook knowingly violated the civil stalking protection order. Specifically, the court finds the following incidents to be in violation of the CPO. He has 3 violations, and here they are. Number 1, the incident at the sheriff's office. Isn't that interesting that Ohio clearly has found them both guilty for being at the sheriff's station? And yet Florida has swept it under the rug and done absolutely nothing. Of course, now they can't. They can't sweep it under the rug anymore. They've already been found guilty in Ohio and has to transfer over into Florida. But I'll go on. Hales testified credibly that Crook was in the Preston vehicle when the vehicle was in 500 feet of Hales' vehicle while parked at the Levy County Sheriff's Office. And the county does not find, the court does not find credible Crook's testimony that Preston was directed to park at or near Hales' vehicle. How could they? They were already parked there when Deputy Tummins went out and told them to get away from my vehicle. Nobody can direct them to park towards or next to me when they were already parked there. In other words, the judge is saying, you're a big fat liar, and she just debunked the Crook. All right. And the court finds that to be a knowing and willful violation of the CPO. Now, keep in mind, knowing and willful. So, for example, the next one is the incident in the road. So, Crook's in the road, and while the civil protection order is very clear, he can't be on any private or public road within 500 feet. There is an aspect of me coming out of the road, and while he could have easily moved over, you have to get into this knowing and willingly, and you have to be able to prove it. So she goes on to say, incident in the road with Hales. Hales testified credibly that Crook yelled at him, "Suck my quack," while Hales was driving down the road and Crook was walking in the road. You understand that, right? She got that from LIEnette's video. The court notes that Hales purposefully slowed down his vehicle. Absolutely. I'm not going to breeze by. I'm not going to fly down a road when somebody's in the middle of it, regardless of how I feel about that person. And he slowed down his vehicle while he was filming Crook in the road and reminded Crook he needed to stay away 10 feet. The court does not find Crook being in the road while Hales purposely slowed down his vehicle as a violation of the CPO. However, the court does find Crook yelling at Hales, "Suck my quack," during this interaction as a violation. So now we have 2 violations. Number 1, he's at the sheriff's station. Number 2, he tells me to suck his quack. Okay. Number 3, incident in the road with George. Crook admits on cross-examination when George was filming him while he was on his property that George was driving by and he yelled to George, "Stop filming me." Now, again, that's not what he said. He was trying to cover up what he actually said, and his lie got him in trouble and guilty. This admitted communication is a violation of the civil protection order. 3 counts right there. Now, it does have a little subpart, and it says the court notes that George did not testify at the contempt hearing to authenticate the videos. Hales did authenticate the video, although he was not present when the video was taken. Crook did not object to the video as presented, nor its lack of authentication. The court will not make the objection for Crook and will consider the video as presented. Okay? And then she gives the legal case for that as well. In other words, he's guilty. So 3 counts of guilt. Sheriff's station, telling me to suck his quack, and then communicating with George as she's driving by.
So he admitted to all 3, but he's innocent and it's fraudulent.
Innocent! It's fraudulent! These fraudulent civil protection orders, fraudulent charges. I stand to lose everything. My beautiful property, my beautiful home. I have yet to see anything beautiful over there. And then the court goes on to say, the court specifically does not find the internet postings to be a violation of the civil CPO, as there's no direct communication with the protected party. Now, this is a split thing for me. I think it's a good thing that the Ohio courts are upholding the First Amendment right, freedom of speech, while Florida and Judge DeThomas's are undermining it and trying to get rid of the foundational freedom of speech First Amendment. Okay? And so this is great. Everybody, I will fight for everybody's freedom of speech. In fact, that's what I'm doing. Even as I'm fighting and battling in court with LIEnette and Crook and Judge DeThomas's, I'm fighting for all of their freedom of speech. Judge DeThomas's can say anything he wants about me as long as it's protected speech. LIEnette can say anything she wants about me as long as it's protected speech. Crooks can say anything he wants about me as long as it's protected speech. I don't care about people out there going, "I hate you." Great. Do you really think it affects my life, what you think about me or say about me? It does not. It has nothing to do with my life. I keep on living and enjoying my life. And they should as well. They have the freedom to say, "I hate you. I think you're a jerk. Or on the other end, Jeremy, you're the greatest." Listen, I don't pay attention to either of those. One side is 95% of the people, I always tell this to George, 95% of the people will love you, 5% of the people will hate you. Don't ever focus on the 5% that hate you, because they only do, all they know what to do is to hate. Let them go hate somebody else. Put all your energy in the 95% who love you, they'll love you even more. For example, Christmas in the Creek. We put 95% of our energy in all the people and love and giving it back. And because of that, people are wanting to give back more. We have people already wanting and begging to sign up for Christmas in the Creek, wanting to be a part of this. Gifts are already coming in for Christmas in the Creek. Do you see how it works? And so at the same time, those who send messages or comments and say, "I love you, you're the greatest, and I wish I could meet you and get your autograph," and then we get those, "I hate you, I want to unalive you," and da-da-da-da-da. Neither of them on either spectrum should change your life. You live life the way that you should live life, not giving weight to either or, and nor the middle. Just live your life and do the best you can with it. Do unto others as you should have done unto yourself, right? We all know that. LIEnette started this. We were so patient. I was just talking with Madam Mayor and her husband on the drive back here to Florida, and we were talking about, how did it get to this point? Well, and Brett goes, "Well, they should have acknowledged the civil protection order in the first place."
The cease and desist.
Or the cease and desist. And I was like, no. They should have never talked all this trash about you and Madam Mayor, about us, about every other resident in Otter Creek. None of this should have ever came out of their mouths as they posted all this garbage all over the internet and said all these horrific, vile things. And the people here have been so patient with them. And it was until we said, all right, enough is enough. And it goes on because the judge said enough is enough. According to the court, finds that respondent John Crook is in contempt of court based on the violation of Section 4 of the Civil Protection Order issued on October 31st, 2023. Respondent Crook is fined in the amount of $100 for the contempt. So LIEnette was fined $50. Crook is fined $100. The court hereby cautions respondent Crook that any, and it's capitalized, she is very serious, that any future contact with petitioner or any protected party, meaning George, that any future whatsoever will result in further motions for contempt, which already is. We are already filed in the Ohio courts, mandating that they must be there in person, and possible criminal charges, which I have no doubt this next one, they are going to get criminal charges. Hour and a half, intentionally, knowingly, willingly broke the civil protection order. Respondent Crook has warned that the 5-year civil protection order, so that's one of the things that we did in this contempt hearing. There was a 2-year, we asked it to be increased to 5 years. She increased it. It is now 5 years on LIEnette and Crook. The 5-year. We ain't going anywhere. We're staying in Otter Creek 5 years and beyond. The 5-year civil protection order remains in place, and you should have no further contact, either directly or through another person. And this is the funny part, because LIEnette keeps using third parties like Marla Hughes. The other person with the petitioner or any protected party of the CPO. Petitioner Jeremy Hale's motion for contempt is well taken. It is granted. As you can see here, it is granted. Respondent John Crook is found to be in contempt of court. As punishment for the contempt of court, respondent John Crook is hereby fined $100. As a first offense of contempt, the court will impose a term of will not impose a term of imprisonment. You know, I'm doing this backwards and upside down, but will only issue the fine of $100. The court goes on to say, we'll note that any additional findings of contempt may result in additional fines and jail time. And we feel very confident that jail time is coming very soon, because just in a number of weeks, we're going to be in Ohio court again for further charges against them.